You guys can all see me. Well, for those that have not done this before, welcome. Even if you have done this before, I'm still going to welcome you. My name is Lior Samfiru. As you see that on the screen, it's a bit of a mouthful. But what matters is not so much my name, it matters what I do. And that is, I'm an employment lawyer. As an employment lawyer, what I do every day, all day, is I solve workplace problems. I solve workplace issues. And that's what I'm here to do on this session, like I do every week. This is a live Q&A, a live session for you to ask your questions about employment law, about your job, about your rights, about anything in the workplace that may have happened that's raised questions. Maybe it's about vaccines and can you get vaccinated? Maybe it's about losing your job. Maybe it's about changes to your job, working from home. You name it, now is the time, now is the place to ask questions. You see that box on your screen, you can type in your question, press return, and I will see the question, I will answer it, and you can walk away with all the information that you need. So again, welcome to this Facebook Live session. We cover all of Ontario, BC, and Alberta. My name again, Lior Samfiru. I'm the head of the employment law practice at Samfiru Tumarkin LLP, and I very much enjoy answering questions. But you may not be able to get your question asked, or you don't feel comfortable asking questions on this session on Facebook or on YouTube. That's okay. There's always the second option. The second option, very easy, is you contact me off air. You contact me directly by phone or by email, and here's how you do that. All you do is you go to employmentlawyer.ca. Again, employmentlawyer.ca. And when you go there, you'll have all the contact information that you need, phone number, email addresses, online forms, you name it, it's all there. So if you want to have a private chat off of social media, that's the place to go. Just reach out to me through employmentlawyer.ca. But that's after. Right now, I'm live, you're watching. Ask your question about workplace rights. I'm going to start answering them momentarily. And we want to have a discussion going here. By asking your questions, you'll be helping others who are struggling with the exact same issues as you are. So don't be bashful. Now is not the time to be bashful. Ask your questions live. I'll answer them live. And to get us started, first question comes from Cindy. I'm ready to terminate an employee. What is the Ontario requirement for termination pay? He's been with us 12 years. So Cindy, entitlements are based on three factors: person's age, position, and length of employment. So I know his age, I don't know his position or age, but you could owe this person as much as a year's pay, 12 months pay. The only time you can pay less is if you have an employment agreement with the employee that limits entitlements. So you could be 12 months, it could be anywhere from 8 to 15, depending on the person's age and job. But we need to talk about this. Don't want you to terminate this employee without us discussing how we do this properly, how we set up the severance offer for this employee. To do it properly, there's ways to minimize exposure. But you could potentially owe this person as much as a year's pay. And by the way, Cindy, if you had a proper employment agreement with this person, you would only owe them 8 weeks' pay. So it could be the difference between 8 weeks and 12 months. That's why it's so important that we have proper employment agreements. So Cindy, what you may want to do is, regardless of this employee, let's talk about drafting employment agreements for your employees so that you don't have to worry about this. It will literally save you tens of thousands of dollars, okay? So give me a call, perhaps connect with me off air. You can do that through employmentlawyer.ca. Again, employmentlawyer.ca. In the meantime, thank you for that question. Follow-up questions, please bring them forward. Or you as well, at home right now watching, ask your question. Don't hesitate. Next question comes from David. I was working for a temp agency for 9 months. At the end, I had 3 days of my regular shift canceled, and I called in sick the last day. They then resigned right after that. I also wasn't getting hired on as fast as my coworkers and felt like I was a good worker. Could I sue and get constructive dismissal? So it's a question of what actually was happening. If they were avoiding finding you work, then sure, yes. If they were trying but they couldn't find work legitimately, then no. So we need to understand what happened here. But it's important to understand that just because you were working for a temp agency doesn't mean you don't get severance, not at all. You may well get severance, but I need to understand exactly the type of job you were doing, for how long, how many shifts usually, did that change regularly, or is it always the same? So the devil's in the details, right? The more you can show me that you had a consistent job and then that changed, the more likely you are going to be able to say, no, that's a big deal. that's a constructive dismissal. So hopefully that makes sense, David. Feel free to ask a follow-up questions or connect with me through employmentlawyer.ca so we can have a private chat. Next question. Okay, I think I answered that. Next question from Singular Seeker. Short-term disability. Can an insurance company decline to pay even with the doctor's note? At this point, it is pending, and I have been living off my savings for 2 months. The reality is no, Singular Seeker. If your doctor says you cannot work, your insurance company should be paying you. They shouldn't be questioning your doctor. But the fact that they should not be doing that doesn't mean they're not going to try. And the reason they're going to try is that a lot of times when people say, no, when they say to people, well, you're not going to get benefits, people give up. People say, oh, well, they said no, so I guess I have nothing to do. So they're counting on the fact that some people will not push back. If they approve you as they should, no problem, life's good. If they're not approving you, call me right away. We have a whole team at my firm just dealing with these disability issues. We can get the insurance company to do what they're supposed to do. If your doctor says you cannot work, then you cannot work, and your insurance company should not say, well, we disagree, okay? That's very clear. If they do anything other than approve you, anything, call me. In fact, if they delay much longer, you want to call me as well, all right? Employmentlawyer.ca to do that. Barbara, thank you, Barbara. From Shane, I was terminated because of COVID. Do I have the right to view my personnel file? Unfortunately not, Shane. An employee does not have a right to view their personnel file, but it really won't matter anyway. It's a question of severance, okay? You're owed severance, and the personnel file is not going to change that. And severance, Shane, could be as much as 24 months pay. So let me ask you some questions, Shane. Tell me how long you've worked there, what kind of a job, and how old you are, and tell me what they've offered you by way of severance. Then I'll be able to tell you right now how much you're actually owed. So, and I can almost guarantee you that you're owed more than what you've been offered, because that's the case for most people. So the issue really is not the personnel file. The issue is, what are you legally owed? So your age, your position, and the length of your employment, and also what they offered you. All right. Next question from Kelly. And guys, ask your questions. Getting lots of questions coming in. I love that. Ask, ask, ask. I have a friend from Kelly who is being bullied. There were rumors being spread, and even a sexual comment was made to her. She went to HR, and they said they would be doing an investigation. After months, they came back and said they spoke with those involved. They denied it, and because she doesn't have dates and times, they cannot do anything. Should HR have asked all staff or just the ones my friend reported? Well, it really does depend on the allegations, but in most cases, the company should do a comprehensive investigation. The thing is this: if she doesn't have documentation, now is the time to start documenting. Now, one of two things will happen. Either the harasser has kind of been scared off by the investigation and they'll behave themselves, or they won't. If your friend is still subject to harassment, starting now, she needs to start documenting things. Have a journal, a diary when she writes dates and names. If someone says something to her, send an email to that person right away saying, today you told me this and that. I don't appreciate that. Please stop. By doing that, she creates a record. Then she goes to HR with that record, and guess what? Things will happen really, really fast. So it's important when it comes to harassment to document things. You never want it to be your word against someone else's. That's not going to be very effective. So tell her to document starting now. She could potentially have this resolved very, very quickly, but have her documented. If she wants to talk to me, talk more strategies, please have her reach out to me. Happy to chat with her through employmentlawyer.ca. Again, employmentlawyer.ca. For you at home, ask your questions. I'm going to continue answering. You see how easy it is? No, nothing to it. So please ask your questions. Next question from Joe Smith on YouTube, I believe. Is it possible workplace insurance plans will require vaccinations in the future and legally be entitled to do so? So far, my workplace insurance does not, but this is a concern. They're not going to do that unless there's something that the government does. So the only way an insurance company or an employer is going to be able to require vaccines is if the government says that you have to do it. or the government allows them to do it. They're not going to be able to do that without government intervention. And so far, the government said they're not going to do that. So no, I do not expect that that's going to be something that insurance companies do. And for those of you at home, you should know that your employer cannot force you to get a vaccine. Now, I think personally people should get vaccinated. But if you choose not to, your employer cannot make you. They're not allowed to fire you because of this. They're not allowed to threaten you. If you find yourself in that situation, let's talk. Give me a call. Connect with me through employmentlawyer.ca. So, by the way, I'm hearing him from Wally saying the sound is not very good. Can you let me know? Can someone type in and say, can you hear me okay? Obviously, I have no way of knowing, but if someone can just type in, yes, we can hear you, or no, we can't. That would be helpful. In the meantime, I'm going to continue with Razor Sharp on YouTube. How difficult is it to prove workplace discrimination? I work in a casino and I'm subject to very racist and discriminatory practice, but don't know how to deal with it. So first of all, it's not difficult if you can show it. All you have to do is either, you can have a recording, you can have a witness, you can have an email from you to someone at the time confirming what happened. That's very credible. So someone makes a racist comment to you over lunch, send them an email an hour later saying, hey, Bob, you made this racist comment at lunch. I don't appreciate that. Create that record. It's not difficult. And once you have that, an employer has to legally do something about it. They can avoid to, they have to investigate and take measures to rectify that problem. So you simply saying, I remember 2 weeks ago, Bob said something to me, is not good enough. On the other hand, if you can say, me and Joanne heard Bob say it, or here's a recording, or here's an email that I sent Bob when he said that, that is helpful. That is how you prove harassment. So keep that in mind. Honestly, it's not difficult at all to do, but you do have to put a bit of work into it. So hopefully that, okay, people can hear me. That's great. I appreciate that. So if you can hear me and I can see your questions, you know what to do. Ask your questions. Post them up right now. Let's talk about that. If you have any questions, we're live. I know a lot of the questions I've been getting over the past few weeks have had to do with vaccines, whether an employer can require vaccines. I had someone contact me the other day saying their employer said they have to get a vaccine by June 1st or else. No, an employer cannot do that. That's not appropriate. I know we're hearing stories about south of the border in the US, employers are doing that. Very different laws in the US than in Canada. What they may be able to do down there does not mean an employer can do here in Canada. So if you have any issues or questions, you know what to do by now. Reach out to me through employmentlawyer.ca. All right, next question from Facebook. This comes from Melanie. Says, I'm off on stress leave due to toxic workplace. The doctor advises not to go back and get another job due to mental stress. Is anything owed since being employed for 15 years? So absolutely, if you can show what happened to you, in other words, why it was a toxic workplace, that it actually happened, then yes, you could be owed as much as 16 or 18 months pay, maybe even more. Keep in mind though, the people that made it a toxic workplace are not just going to put up their hand and say, yes, sorry, we did it. They're not. So we have to prove it. So my question always is going to be, how do we show that it was a toxic work environment? Do we have other people that are going to corroborate it? Do we have emails? Do we have anything in writing to show, here's why I'm sick, here's why I can't go back to work, as opposed to other reasons? But if you can show that there was a toxic environment, that you were mistreated or harassed or bullied, yeah, that's considered a constructive dismissal. It's not your fault in that situation that you can't go back to work. It's because the employer didn't provide you with a safe work environment. Meaning, yeah, they have to pay you potentially as much as 18 months pay. So Melanie, I see you say you have emails, then sure. Here's what you need to do. Here's the next step. The next step is you reach out to me through employmentlawyer.ca. I'll give that to you again, employmentlawyer.ca. You'll see my email address there, Melanie, my phone number. Okay, you can connect with me there. You see right here on the screen, employmentlawyer.ca. And then we'll talk about how we go about getting that compensation. Your employer is not just going to write you a check because you asked for it. We're going to have to do some work to get it. But if you have emails, as you said, it's not going to be difficult. So I want you to reach out to me, employmentlawyer.ca, and I'll help you for sure. In the meantime, hey, we have more space here, more time, plenty of time to go. So ask your question. Let's make sure that you leave here with your questions answered. No being bashful today. Next question from Evelyn. If after July 3rd, the ESA temporary layoff rules end, what are the obligations of the employer to anyone still in a temporary layoff? Well, the obligation is to take you back. And if they don't take you back, they have to terminate your employment with severance if there's no possibility to give you another job. So they have to take you back or have to pay you severance. And remember, severance has to be as much as 24 months pay. Here's what I expect will happen, despite what I said. A lot of employers are not necessarily going to do that. They're going to say, okay, the government leave of absence has ended. We're going to now put you on a temporary layoff. Can't do that, okay? Cannot. If they do, and you accept it, you could stay on that layoff for another 8 months. Nonsense, right? So if your employer does anything other than take you back, you call me. You call me right away or you email me right away, and let's talk about the severance that you're owed. To stay on for another 8 months would be absurd to me in many cases. Employer may try to do that, but they're supposed to take you back or pay you your full severance. All right. And by the way, you don't even have to wait till July the 3rd. No, hopefully this is okay. I'm having some issues here, Dan. I'm not sure if you can see that. Okay, well, hopefully you guys can see me. I'm not sure I can read any more questions. I'm getting an error message here. So let me talk about a few things. If you can ask questions, please do that. I'm not sure I'm going to be able to say. Then it says, looks like your embed link is invalid. Visit the chat settings and grab a new one. That's what it says. Okay, so let's continue now. And I want to tell you about another link that you can use to find out your legal information. And that is pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. What that is like having your own employment lawyer with you at all times on the phone, on your laptop, on your desktop, tablet, what have you. When you go to pocketemploymentlawyer.ca, we have a number of employment law tools. The most popular one is our severance calculator tool. You can find out now in seconds how much severance you are owed. Maybe it's 2 weeks, maybe it's 24 months, or maybe it's somewhere in between. It's easy to use, it's free, it's anonymous, and it's extremely helpful. It's the only way you can get an accurate assessment of your entitlements without leaving the house, without picking up the phone. pocketemploymentlawyer.ca. But it does a lot more than that. It can determine whether the company had cause to let you go. It can determine whether you're an employee or an independent contractor. Many people are misclassified. It can do many other things as well. It can determine whether your matter is a human rights matter, if it's considered discrimination, and more as well. Like I said, it's like having me, like having an employment lawyer from my team with you at all time. So just go to pocketemploymentlawyer.ca. But right now, it's time to ask questions. Again, I'm live, you're live. Ask your questions. Let's find out as much as we can about workplace rights. In between your questions, I want to answer a few common questions that I've been getting over the last number of weeks. A big one is, can my employer change the length of my shift or change my hours of work? Big question I've been getting. My employer wants to make my shift shorter. Maybe they're saying they're not enough work. Or I used to work day shifts. Now they want to put me in the evening shifts. Or instead of starting at 9, they want me to start at noon. Those types of changes. Question I've been getting is, can my employer do that? And the answer almost always is no. Your employer cannot do that. Your employer cannot change the terms of your employment in a significant way. They can make some very minor changes, but they cannot make significant changes. If they do, if your employer changes your hours, your job, your shift, you can treat that. You have the right to treat that as a constructive dismissal. You can say, I'm not accepting that. I'm going to look at this as a constructive dismissal. I'm going to leave. An employer, you have to pay me my full severance. So that's why we call it constructive dismissal. So even if it's COVID-19 related, the law has not changed. You can still look at a change in your employment as a constructive dismissal. Keep in mind, if you don't do that, if you continue working despite the employer changing your shift, your hours, your pay, what have you, is by accepting it, you've given the company the right to do it again. And the next time they do it, you won't be able to do anything about it. That's why it's important to stand up for your rights. If you find yourself in a constructive dismissal situation, before you do anything, I want you to contact me. All right? Contact me through employmentlawyer.ca. I'm going to continue answering questions. In the meantime, ask your questions. I'm live. You're live. So let's answer questions. This is a question from Esfandier. I apologize if I mispronounced it. Is a gas station worker entitled to severance? Absolutely yes. And that's a very important question because there's a lot of misconceptions. Well, this type of job or that type of job doesn't get severance. Part-time employees don't get severance. Nonsense. None of that is true. If you have a job and you lost that job, you're owed severance. It's as simple as that. Of course, we're talking about non-union employees, no union. But for a non-union employee, if you had your job and you lost it, you are owed severance. So as Fandier, not only are you owed severance, you're owed potentially as much as 24 months pay. So if you want to know how much you're owed or find out for yourself or a family member, I said it before, pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca to find out how much you're owed and to get the severance that you're owed right there, easy, anonymous, free. So check it out. In the meantime, as I'm waiting for some more questions, let's answer a few more common questions that I've been getting. So another one is, can my employer punish me if I complain about workplace harassment? We talked about workplace harassment earlier. So no, once you raise an issue, you complain to your boss, to HR, you have this protection, I call it the dome of protection around you. You cannot be punished in any way for complaining about harassment. You cannot. You cannot be threatened or let go or disciplined. That's illegal, completely illegal. Not only can you not be punished, your employer by law has to take the complaint seriously, has to investigate, and ultimately has to take all available measures to fix the issue, to rectify that problem. So do not worry about raising it as an issue. You should and you have to raise harassment as an issue. You have a right to work in a safe and a supportive work environment. If the work environment you're in is not that, it's a poisoned or a toxic work environment, complain about it. Tell HR. If they don't do anything about it, if you can't deal with that internally, then deal with it through me, deal with it externally. That's when you contact me. But you cannot be punished in any way for complaining about workplace harassment. Never. Next question comes to us from Linda. What if my employer fires you with a written explanation that you filed harassment against her? Well, we were just talking about that. That's illegal, Linda. Your employer cannot fire you because you filed a harassment complaint. And if they actually put that in writing, that's what they did, that's absurd. That's ridiculous. That employer is just, I don't even know what the word is. They're going to have a lot of questions to answer and a lot of damages to pay if they fired you because of that. So, Linda, you have to give me a call. I'm not even going to allow you not to give me a call. You must give me a call. And do that by going to employmentlawyer.ca. Employmentlawyer.ca. You'll see my phone number, my email address. You have to call me. If that's what happened to you, yeah, that employer is going to have to pay. That's illegal. Can't do that. Not now, not ever. Thank you for that question. Ask yours as well. Question from Suzanne. My former employer is refusing to give me severance, saying that I've waited past the 2-year threshold. I worked there for 12 years. Well, Suzanne, unfortunately, there is a 2-year limitation period. Okay, so I don't know why you waited. Hopefully, it's not a health issue, but we may still want to have a chat. In some cases, there's some, especially now with COVID, there's the ability to extend that limitation a bit. But it's always a bad idea to wait when it comes to your severance, because your legal rights can expire, and there is a 2-year limitation period. So let's chat though, but not tomorrow, not after dinner. Let's talk immediately, because time obviously is not on your side here. Time is not your friend right now. So we need to discuss that as soon as possible. And for everyone else, if you've been let go, don't sit on your rights. Don't wait. Don't think, well, I'm too stressed about it, I'll deal with it later. I know it's stressful to lose your job. I get it completely. But you have to deal with it now. Let's get you that compensation that you're owed so that you can relieve some of the stress. A lot of the stress you have when you lose your job is thinking, oh my gosh, how am I going to pay my bills? How long is it going to take me to find another job? Well, guess what that severance does? It's like an insurance policy. It's there to carry you until you find another job. It's there to help you pay your bills while you're looking. So you need that severance. That's why it doesn't make any sense to wait if you can avoid waiting. So if you lost your job, first person you call is your significant other, husband, boyfriend, wife, whatever you want. Second person you call is me, okay? Always. First person, significant other, second person, me. And you do that again going through employmentlawyer.ca. We have a few more minutes, guys, so ask your questions. Don't be bashful. This is a follow-up from Linda. Employer fired employee because she filed a harassment complaint. Explanation of this is in dismissal letter. Well, Linda, that employee has to call me. It's illegal. We've talked about that quite a bit over the last few minutes. And for them to even say that, can you imagine the employer saying, we're letting you go because you filed a harassment complaint? Wow, it's illegal. May as well say that we're letting you go because you're too old. It's that illegal. Can't do that. So if you're a friend, if it's you you're writing about, or a friend or a colleague, call me. Have that person call me. Employmentlawyer.ca is the place to go to. Let me talk about another question that I've been getting often, and that has to do with it has to do with temporary layoffs. And can my employer keep me on a temporary layoff indefinitely? No, your employer cannot. In fact, your employer doesn't have a right to put you on a temporary layoff at all. We're talking about non-union employees, of course. For a non-union employee, your employer does not have an automatic right to put you on a layoff. So if you've been put on a layoff, you only have two choices. Choice number one is you can accept it and stay home and see if and when they'll call you back. Choice number two is you can look at that layoff as a termination. You can treat it as a termination of your employment and say, I'm not accepting it. I'm going to consider you to have let me go. Now you have to pay me my full severance. All right, so very important. If you find yourself in a temporary layoff, keep those two choices in mind. Do you accept it? Sure, that's your right. You could be off for many months, but that's your right. Or do you say, no, enough, that's a termination. You can do that on day one. You can do that later. You don't have to do that immediately, whenever you want to. So if you've just been laid off, or if you've been laid off now for a while, if you want to say enough is enough, if you want to get your full severance, call me, connect with me through employmentlawyer.ca. Next question from Odalis. Is reducing work hours the same as a constructive dismissal? Well, reducing hours results in a constructive dismissal. A constructive dismissal happens when the employer changes the terms of employment in a significant way. So reducing your pay, or reducing your hours, or changing your hours, or demoting you, all of those things are not things an employer is allowed to do, and you can treat that as a constructive dismissal. So that is, if your employer reduced your hours, yes, that's a constructive dismissal. But you only have a short time to deal with it. If you wait too long, if you say, well, let's try it for the next couple of months, too late. By then you're considered to have accepted it. You only have maybe a couple of weeks to deal with it. So if you want to say constructive dismissal, Dalis, you know what to do by now. Reach out to me through employmentlawyer.ca. All right, last question for the day, I think, will be from Ruby. They want us to stop working from home and return full-time. I don't have childcare. I want to continue to work 2 days a week in office and take emergency infectious disease 3 days a week. My employer may say no. What can I do? If you don't have childcare, then you can take time off. If you legitimately don't have childcare, but be prepared for your employer to ask questions. What have you done to find childcare? What happened to the childcare you wanted? Who did you have in advance? Why isn't that person available now? Is there family members? But if you legitimately don't have childcare and you can show why, your employer has to accommodate you, okay? Giving you flexibility, working from home, etc. So saying I don't have childcare is not good enough. You need some more information for your employer. If your employer won't accommodate you, by now you know what to do. You contact me through employmentlawyer.ca. You know what? I said last question. I lied. I'm going to take one more from Ioana. Maybe I mispronounced. My husband's employer sent him home as they could not give him modified work per his doctor's note. Employer told him to go on STD again. What happens if he still needs modified duties? So the first question is, can the employer accommodate but they choose not to? The fact that the employer says we don't have modified duties doesn't mean that that's the case. In some cases, an employer can accommodate but chooses not to. If that's the case, that's a human rights violation. If the employer legitimately tried to find modified duties, but there's just nothing available, the employee can go on STD or on short-term or long-term disability until either the employer has the ability to accommodate or until the employee no longer needs that accommodation, okay? So if you're not sure that the employer is being honest in this situation, let's speak about it. If you're convinced that the employer is doing everything above board, your husband can go off on a disability leave and something will change at some point. Either your husband will do better or the company will have available benefit or available accommodation for him. But don't take the employer's word at it. In many cases, it's simply not the case. Your husband should be accommodated, but the employer just doesn't want to. That's illegal. There's a very strict duty to accommodate. Okay, this half hour flew by. I am happy I got to answer a lot of questions, but just because we're going to be shutting off our social media now doesn't mean that I'm going anywhere. You can still reach out to me now if you want through employmentlawyer.ca. Again, employmentlawyer.ca. I will continue answering questions. You can contact me, email, phone, all is there. I will be back, of course, next week. You don't need to wait until then. Contact me right away if you want to. But otherwise, of course, we'll be back same time, same place next week. My name is Lior Samfiru. I'm the employment lawyer. Thank you very much for joining me. Employmentlawyer.ca to connect, and I'll talk to you later.